1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. I took a short break to watch People's Exhibit 401. And by the way, the record should reflect that we're still outside the presence of the jurors. After watching the tape, it is admitted over the defense's objection. It has some probative value. It shows people running out of the theater, presumably at the time of the shooting. It shows some employees of the theater taking action, again at around the same time, as far as initially hiding and then one of them leaving the theater. The other one, I think, actually stayed behind, hidden under the counter. It is evidence of the circumstances surrounding the shooting, and so it has probative value in that sense. It also has probative value because it depicts the commotion, the chaos, and the panic that have been described by witnesses. Another witness talked about how there were a lot of people in the parking lot and it was hard to get to the theater. I think several first responders have talked about that, and so I think this is evidence that goes to that as well. And in terms of its prejudice or prejudicial effect or potential prejudicial effect, it is somewhat prejudicial. I don't find it to be particularly prejudicial. And certainly the prejudice or the potential for prejudice does not substantially outweigh the probative value of the evidence. Given what's at stake here in terms of the charges, in terms of the magnitude of the crime that is alleged, in terms of what we're dealing with here in this case, I don't find that this is particularly prejudiced. And so for all those reasons, I find that it is relevant under 401 and 402 and that it is admissible under Rule 403. All right, let's before you bring the jury in, with respect to this exhibit, the witness should not provide an explanation. This one does not need an explanation. This is different than 400. Exhibit 400, I felt that without allowing the witness to provide some type of explanation as to what he thought was being depicted, it was going to be hard for the jury to follow it. And so I allowed that. I allowed that for purposes of identifying who he believed was the defendant in the surveillance video, and for purposes of allowing the jury to understand that evidence better. But I gave the jury a specific cautionary instruction to make sure that they understand that it is entirely up to them to decide what is depicted in that video. All right, let's bring him in, please. Here you go, Ms. Pearson. The record should reflect that the jury's back in the courtroom. Welcome back, folks. Please be seated, everyone. Members of the jury, I have admitted Exhibit 401, People's Exhibit 401, and it may be published now. the record should reflect that People's Exhibit 401 was just published. Do you have any other questions, Ms. Pearson?
Yes, Your Honor, a few more. As part of your duties in response to the shooting at the theater, did you work with the crime scene investigators in collecting evidence within the theater?
Yes, ma'am.
As part of that, were you involved in checking the roof of the theater to see if any projectiles had been fired through the roof of the theater?
Yes, ma'am.
When did that occur?
The 21st,
So,
July 21st, 2012,
do you think that was the 22nd?
22nd.
How did you go about doing that?
There is a roof access through the projection room. If you recall how the theater was set up, the projectors at the top, behind it is a room that has roof access. We climbed up a long ladder, a chute ladder that runs up to the roof, and then we physically walked around the roof looking for any apparent holes on the roof.
Did you find any?
No.
Any indication that any rounds had been shot into the roof of Theater 9?
No.
Thank you.
Do you have any cross-examination, Ms. Spengler? No. Okay. And there do not appear to be any questions from the jury. So, may this witness be released from his subpoena?
Your Honor, we would ask to keep this.
All right. All right, sir, you are subject to recall, okay?
Yes, sir.
All right, thank you. All right, members of the jury, it's 3:25, and as I indicated to you, we're going to end today at 3:30. Since I have 5 minutes, I'm going to take just the 5 minutes to go over the admonishments. You knew I was going to do this to you, and you're all smiling. I'm still going to get you out of here in time to watch the NFL draft today, so I don't know if you have any NFL fans there. But I want to remind you that there are rules that you must follow. These are the same rules that jurors have always had to follow in trials. During the trial, this courtroom is a place partially isolated from the outside world. Your decisions must be made inside this place, and you must follow its rules. You must decide this case based only on the evidence presented in the courtroom and the law as I instruct you. You must avoid any other information about the case from any other source. These rules are designed to make sure that there is a fair trial. There are two basic general rules. Number one, you must not communicate with others or among yourselves about the trial as it is going on. Number two, you must not do any independent investigation or research about the case. Let me discuss these two general rules in more detail. You must not discuss the case among yourselves in any way during the course of the trial. You may not discuss the case among yourselves until after you've heard all the evidence and I tell you that you can begin deliberating on a verdict. In fairness, you must keep an open mind throughout the trial, and you may not form any opinions about the case or reach your decisions until I tell you that you may start deliberating on a verdict. Do not permit anyone else to discuss the case with you or near you. If anyone, including one of your fellow jurors, attempts to do so, please report that fact to my staff immediately. And if you report anything to my staff, do what you've been doing. Just say, I need to talk to the judge. Do not go into any detail. Do not talk with any witnesses, parties, or any of the attorneys who are involved in the case. You cannot talk to them, and they cannot talk to you even casually. Do not communicate about the case with anyone else in any way, including in person, by telephone, cell phone, smartphone, iPhone, BlackBerry, computer, the internet, or any internet service. This means that you must not email, text, instant message, tweet, blog, or post information about this case or about your experience as a juror on this case on any website, listserv, chat room, blog, or website, such as Facebook, MySpace, LinkedIn, YouTube, or Twitter. You must not read, review, or accept any communications in any form from anyone regarding this case or cases like this one. Therefore, you may not mention that this is a criminal case or the charges that have been filed in this case. You are permitted only to explain to family, friends, and employers and others that you're on a jury and that we anticipate the trial will last 4 or 5 months. You cannot say anything else about any aspect of the case or any aspect of your experience as a juror in this case. You cannot be investigators outside the courtroom. Attempting to get further information outside the courtroom would be unfair to the parties and would be a direct and serious violation of your oath. Do not attempt to gather any information on your own. Do not read or research about this case or this kind of case from any other source, including the internet. Many of us routinely use the internet to research topics of interest, but you may not do that in this case in relation to the case. You can still use Google and Bing and Yahoo, but you cannot use those internet search engines to learn about any person, place, or thing that is involved in this case. That includes the defendant, the attorneys, the witnesses, your fellow jurors, and court personnel. And this applies whether you're here at home or anywhere else. Please do not read about the case in the newspapers or on the internet, or listen or watch any radio or television broadcasts about the trial. The law even prohibits you from consulting a dictionary or any treatises or the Bible or any other source in connection with this case or in relation to this case. Do not attempt to visit any places mentioned in this case. Do not in any way try to learn about this case or this kind of case outside the courtroom. So all scientific books, all religious books, all legal books, those are all items that you should not be consulting in relation to this case or in relation to your service in this case. Obviously, you can use those items, just not in relation to this case. Does that make sense to everyone? Okay, and everyone's nodding their head yes. I mentioned this the other day. There are times when you're not here, when the attorneys and I have discussions. Today will be an example of that. After you leave, we're going to work a little longer. There are some things we have to talk about. Because we have the media here, it's possible that there may be media coverage of some of the discussions we have. You must avoid accessing or learning information about the case from the media. Otherwise, you could be exposed to some of that information that you're not allowed to hear and are not allowed to be present for. That's the whole reason why we have those discussions outside your hearing. And so please be particularly vigilant about media reports. Whether it's in the newspaper, the radio, the TV, the internet. Just be very, very careful about that, okay? All right. With that, enjoy the long weekend, and let's have you back here on Monday morning at 8:15, okay? Remember, bring your lunch next week or be ready to buy your lunch next week. Thank you, folks. Have a great weekend. Okay, everyone may be seated. The record should reflect that we are now outside the presence of the jurors. Let's take a real break now, since with the last break we took was only about 5 minutes. Let's take 10 or 15 minutes, and then we'll proceed with the discussion that we have tabled until today, okay? The court will be in recess.